Hi there, Jasmine from Redwood, and this week's frequently asked question is, does divorce revoke your will? It's a really interesting question because I think our gut instinct would be to say, well, of course it would, but actually it doesn't. Under UK law, divorcing someone does not revoke your will. Once you're officially divorced and you have the decree absolute, it just simply invalidates the clauses and the gifts relating to your now ex-spouse, but the rest of your will stays perfectly valid and intact. So in theory, when someone gets a divorce, you don't necessarily have to change your will. It will still be valid, but any reference to your ex-spouse is simply invalidated. On the flip side, marriage, strangely enough, does revoke your will. So if you go and get yourself remarried, your will then becomes invalid and it's like you've got nothing in place at all. So hugely important that you make sure that you have a will in place. Of course, the difficulty is this period between separation and divorce, which for some people could be a matter of months, but for most of us could be a matter of years. And so in between this time is really difficult because in the eyes of the law, you're seen as still married, even though you're separated. So if your will leaves everything to your spouse and you haven't yet finalized the divorce and got the decree absolute and you pass away, then that will still be valid and will pass everything to your soon-to-be ex-spouse. So it is really important that whenever we go through a separation, regardless of whether we're starting divorce proceedings right away, that we absolutely look at our will and we reassess whether or not our wishes have changed. It may be that while you're separated, you're still happy if anything were to happen to you for your estate to go to your spouse, and that's absolutely fine. But we just need to make sure that we're making that as a conscious decision as opposed to a mistake that we didn't realize was going to happen. For most people, once they get separated, even before the divorce is finalized, they'll typically change their will to leave their estate normally to their children if they have them, or grandchildren, or if not, other beneficiaries and other loved ones that they have outside of their separated from spouse. That means that once they get the final divorce and the decree absolute, the will's already been updated and there doesn't need to be further amendments at that point. So that answers this week's frequently asked question. If you do need any more information, we've got lots more information on things like wills, trust and estate planning on our website. And also you can jump onto our free wills, trust and estate planning webinar at any point for more information.